The wonderful world of creditor rights and duties. First, your book talks about if you're a creditor, you loan somebody some money, they didn't pay you, how are you going to get paid? There are various types of liens. The book talks about mechanics liens, artisan liens, judicial liens. Make sure you know the difference. Mechanics on real property, artisan is on personal property. Judicial liens is when you go to court and get a judgment. Simply getting a judgment doesn't mean you're going to get paid. And you'll see one way to get paid is a process called attachment and execution, also garnishment, which is a pain in the butt for employers because they are actually the garnishee, which makes you Mr. Popularity or Mrs. Popularity with your employer. Uh, a smart creditor will upfront in the contract have some cosigner. That person could be called a surety or guarantee or guarantor. Like if you had a parent cosign on a loan, that's very smart of a creditor to do that. Very important you understand how a mortgage works and the process of foreclosure. Hugely problematic, but very simply, you'll see your book talks about a mortgage. When people say they have a 20-year mortgage, they're really talking about a loan, a promissory note, which is typically a negotiable instrument for 20 or 30 years. That can be negotiated. Now that loan is secured by either unfortunately, a mortgage on the real property, or what we use is a deed of trust. So that's the collateral securing the loan. So if you don't pay the loan, the creditor will foreclose on the real property. And so you foreclose on the security interest, which is called a mortgage or a deed of trust. I try to distinguish this, make sure you understand. When a person says mortgage, they're really talking about two types of contracts. One being a real property agreement, which you'll see has to be in writing and governed by state law, real property law, and is typically a negotiable instrument. And then the deed of trust or the security instrument, which is typically recorded. It's not mandated that it be recorded, but it's foolish for a creditor not to record it. Oftentimes they don't for some reason. Secured transactions, that's another world that you need to get a handle on. Similar in some ways to a mortgage. This is on personal property though, and there's 5 steps in a secured transaction. But it includes either getting possession of the personal property to ensure that you have perfected your interest, or if you don't have possession, you would file a financing statement with the state to establish your priority. Priorities are huge with respect to secure transactions. And if a party defaults on a secured transaction, the remedy is repossession. Important you understand that with personal property, repossession. With real property, it's foreclosure. Real property, the homeowner is the homeowner, and the creditor, the bank, is the lien holder. They're really just foreclosing on a lien, where in personal property, secure transactions, the creditor has ownership of the property and can repossess it if you don't pay them.